Good morning. It is my privilege to be here at the Nordic Innovation Fair, albeit remotely. My thanks to the organisers for accommodating my virtual contribution. My name is Lesley Millar-Nicholson, and it is my privilege to be the Executive Director of MIT's Technology Licensing Office, a position I have held for just over 6 years. It is fitting to start my remarks today with a shout out to your sponsor, Novo Nordisk. Novo Nordisk has a very strong long-term partnership with MIT, investing for over 10 years in sponsored research with a number of faculty, and unlike other sponsors, is actually licensing the resulting IP. It's an important component of what makes our ecosystem work. Strong engagement with our partners who are interested and able to further develop and commercialize IP arising out of our labs and research centres. So thank you, Novo Nordisk, for your enduring relationship with MIT. Let me modestly offer you some insights which I hope will be of value to you, whether inventors, TTOs, startups, corporate partners, or VCs, and all the other parts of the ecosystem that are necessary to make this stuff work. People ask, why is MIT so successful at what it does around innovation? And how can we be like you? Well, we are lucky to have a national infrastructure that not only supports, but actively enables innovation and entrepreneurship, and a culture that tolerates, and in many cases celebrates, failure as a route to success. Whether through our patent laws, our bankruptcy laws, or our federal research funding mechanism and the related Bayh-Dole Act that enables universities like MIT to own IP arising from federal funding, which effectively seeds the culture of tech transfer. These parts make our role in this vast ecosystem a lot easier. But we all know that this work, the work of innovation, entrepreneurship, developing products and services, licensing, strategic engagement, it's rarely easy. MIT itself has a long history of innovation, a tech transfer office, the TLO, that was established in the 1940s under a different name, and is an institution where the practical application of its discoveries was an expectation from the outset. Whether the creation of the fax machine or MIT's contributions to the first digital computer in the 1940s, or more recently components for digital TV, creation of the Roomba robot, and contributions to gene editing. MIT's culture, its essence, is one of entrepreneurship and innovation, and its mission is to ensure knowledge and innovation can be translated to have global impact. So it really is in our DNA. Its history and magnet-like capacity to draw other partners close in the form of corporates, VCs, and entrepreneurs like bees to honey make it what it is today. Match that with the entrepreneurial spirit of the faculty, staff, students, and alumni, and from that, the strong ecosystem both within MIT and around Cambridge and Boston, the facilities, the incubators, accelerators, venture capital, and the accumulation of other educational institutions, and a supportive and an innovative local and state government infrastructure. It's hard to replicate in its entirety, but there are nuggets to learn from. There are over 200 innovation and entrepreneurship programs at MIT, some curriculum-based, some clubs, and other programs created to enhance the experience of students and postdocs, and some to assist in elevating MIT-owned IP. And I specifically differentiate those two things. The ideas from the students created by themselves without involvement of MIT managed funds or major equipment and facilities, and those derived directly from sponsored research, government, or other opportunities afforded to the participants by MIT. The former we do not own, the latter we do. And while our tech transfer offices office assists in the educational programs and seminars and events for students, we don't lay claim to their IP and are often just validating that MIT has no ownership in their ideas before they move on to a business plan competition or start their own company. The ideas from research funding, which we do own, from government and corporate funders, are disclosed to our office at a rate of 650 to 750 inventions a year. The licensing office is located in the center of the renowned Kendall Square, which is right next to MIT campus. I look out on the Google building and can see from our conference rooms many other companies who have chosen to co-locate near MIT, whether Akamai or Biogen, Sanofi, Takeda, Pfizer, Novartis, Merck, and Raytheon. Also within a 5-mile radius, there are incubators and accelerators, CIC, the engine built by MIT, Greentown Labs, Central Labs, Mass Robotics. And in terms of venture capitalists, we're not only familiar with, but we work closely with venture capitalists that invest in MIT startups. Polaris, Flagship Pioneering, Nautilus, Corporate Venture Capital Groups, Matrix Partners, NEA, Atlas Ventures, and many more. However, don't let me fool you. Even at MIT, it is hard to do this tech transfer and commercialization stuff. We all know that from our own corners of the world. It's not without problems. And let me talk about those for a minute, at the risk of dispelling this myth of perfection in Cambridge, Massachusetts. We are not good at everything, nor do we have all the answers to the perfect commercialization system. We have a high volume, as I mentioned, over 700 inventions disclosed every year from over $700 million of research expenditures on campus. We license to 25 to 30 startup companies each year, and I have a pipeline of another 70 or so in the wings, waiting to take flight, to get funding, to develop plans, hire staff, and ready for licensing. At MIT, there is also $160 million of the 700 million, which comes from corporate sponsored research. So we have high volume and we have complexity. The complexity of an ecosystem that encourages and expects collaboration. Our IP is often jointly owned with partner academic institutions. We have no hospital attached to MIT, but our faculty often have clinical appointments at Mass General Hospital or Harvard Medical School or other hospitals. We also have many joint owners who are large companies like Novo Nordisk. It's important for us to ensure that our contractual obligations to them and other sponsors, including the government, are met and addressed as early as possible in the disclosure process. Correct assignment of IP, when to report new inventions to the sponsors, when to trigger license rights, when and if to file the patents, and a favorite topic, at whose expense. On that point, MIT cannot pay for patents that will be licensed, even royalty-free, to a corporate partner. As a not-for-profit academic institution, it puts our not-for-profit status at risk. That is considered giving one party competitive advantage over another. Hence our standard practice to get patent reimbursement for patent filings from corporate sponsored if they are taking any sorts of license rights. Perhaps too much information for this talk, but feel free to reach out for more details. As mentioned, we license to between 25 and 30 startup companies per year, and that process may sometimes be longer than we and the startup company would like. Why is that? Well, in fact, many conversations just start with, so what do you want to do with this IP? What's the plan for funding, for management, development, strategic engagement, fields of use, country of manufacture, future sales, projected milestones? Until we understand all that, and in parallel, talk with the startup about the licensing process, whether they need just an option for a short period of time or a full license because their commercial use is imminent, we will not draft license documents until that is done. And FYI, While I am a proponent of creating easy to use and easy to transact, non-negotiable, non-exclusive license agreements for certain types of IP and products and services, I do not like express startup licenses. What you might gain in speed, you lose in fit for purpose, in building a relationship with the startup, in really understanding the people and their goals, and many a time helping them understand the subtle nuances of licensing IP that is so early stage. IP that will need very careful management and thought to ensure it meets the needs of the company for the long term. However, at MIT, we do have ready to sign non-exclusive software licenses for use by commercial, not-for-profit and academic institutions. Once the party is verified and the code they want is confirmed, it's as easy as click and sign and the code is sent to them. We also have an equity-only exclusive license agreement for non-patentable software code, created because we have recognized the need for an alternative to royalty-bearing licenses, which end up feeling like unnecessary squabbles over something that may not end up in specific products. We do spend most of our time on licenses and options related to high-value IP with startup companies and established companies, and we recognize and accept it will take time. How much time? It depends. We have transacted non-exclusive patentable IP licenses in less than a week. We can do an option in a couple of days if we have all the information we need and agree on the terms. But it is a two-way street, and it often takes months. And we expect our partners, whether large, medium, or small, to have engaged counsel to assist them and to explain the various terms and the risks associated with licensing IP from a research institution. I'd like for a moment to also highlight those not directly doing the licensing. These things that go on in the background of a US tech transfer office and are undertaken by very capable staff. I am sure there are parallels in each of your offices too. We have an office of 55 staff managing 700 disclosures a year, as I mentioned. We have an existing patent portfolio of over 11,000 US foreign pending and issued patents. We have over 600 revenue earning licenses with anything from over $1 million a year to under $10 a year. We have 60% inventions created from federal funding, the balance being from corporate funding. We file approximately 350 US patents a year and spend a total of $21 million on those and foreign filings, with approximately 65% of our entire portfolio costs being reimbursed by licensees, and more specifically for our foreign filings, about 95% of those filings being covered by costs being covered by our licensees. And on an annual basis, we spend 20% of the $21 million just on the new filings, and the balance is on, the 80% is on the rest of the portfolio, those in prosecution, maintenance fees, and the like. From the moment of disclosure, a large engine cranks into gear. We have to affirm the inventions is owned at least in part by MIT. We have to ensure that we have appropriate assignments from each of our inventors. We have to check sponsor obligations, whether corporate or government. If the US government, we have to report directly to them whether we're going to elect title, and then on an annual basis, report to them licenses, products, and country of sale. We have to include in every license of federally funded inventions an obligation by the licensee to substantially manufacture in the US. And if they cannot or do not, their license may be revoked by the federal government. Our compliance team manages these activities as well as those for corporate sponsors. We file patents by using outside law firms, and we have around 6 to 10 we use regularly and a whole bundle of others we use less regularly. Our IP team manages those relationships and the guidelines for engagement with MIT to ensure we're being charged only what we have agreed to pay. Most of our law firms are on fixed fees agreed in advance, and the IP team also manages receipt and confirmation of assignments from everyone at MIT. Our finance team manages invoicing of law firms, invoicing of licensees, and receipts of checks and payments for royalties and other fees due under licenses. They manage accounts receivable and payable, and also do desktop audits of licensees and refer on any major discrepancies for full license audits. Our marketing and communications team manage both our social media presence, LinkedIn, Twitter, and our website, as well as maintaining a flow of technology briefs on our searchable database on our website. These briefs are created by a team of interns who work closely with licensing officers and faculty to ensure the descriptions and information is accurate. All of this is possible because we are supported by MIT operationally through a 15% administrative fee taken off the top of licensing revenue. That more than covers our costs. We are lucky. A study in 2012 in the US showed that only 12% of US tech transfer offices cover their operational costs from revenue annually, leaving them to be supported, sometimes reluctantly, by the university. So as an unfunded mandate, tech transfer does not work. If you leave commercialization offices with insufficient funds to invest in patent filings and have a robust operational infrastructure on a year-to-year basis, and year-to-year and enduring basis, remember that 80% of our $21 million goes to existing filings, then you are never going to build the momentum to have opportunities in the pipeline for licensing startups and economic development, wherever you are, whether Boston or Copenhagen, whether one invention or 700, every tech transfer office in the world has some version of responsibilities and obligations and activities I described above. On that message, I will leave you with a parting thought for the various communities of engagement necessary for doing commercialization well. We are all doing our best, whether we take too much time or don't get something right or forget to respond timely to an inquiry. If we understand each other better at the outset, take a little time to talk before the contracts get drawn and thrown around via email, these things will become more manageable, and we will be able to offer a little grace to each other and build enduring and important relationships for the betterment of our respective and hopefully aligned goals. Thank you for the opportunity to talk with you all. I wish you all a great conference.